Welcome to Explain, a series of health education programs published by the Patient Education Institute, the leading provider of interactive health education. This video includes general medical information and does not replace the medical advice of your doctor or healthcare provider. If you have questions pertaining to your medical condition, ask your doctor or healthcare provider. Advance Medical Directives. Introduction. Advance Medical Directives are instructions you give your healthcare providers. They explain what kinds of medical care you do or do not want if you become unable to make medical decisions for yourself. A living will and durable power of attorney for healthcare are examples of advance directives. In a living will, you specify the medical care you want or do not want to receive if you become unable to make decisions for yourself. Living wills usually apply to end-of-life situations. In a durable power of attorney for healthcare, you appoint someone to make healthcare decisions for you only when you cannot make the decisions yourself. This program explains advance healthcare directives. It discusses the living will, the durable power of attorney for healthcare, and other forms of advance medical directives. The tutorial uses hypothetical situations to explain some topics. It also includes helpful information about applicable forms and getting ready to fill them out. This program is for informational purposes. It reviews the main concepts of advance directives so you are more informed about the issues. It does not replace the advice of your healthcare provider or lawyer. Advance directives. The right to give advance directives is one of the main patient's rights put into law. As a patient, your other rights include the right of informed consent and the right to keep your medical records confidential. As a patient, you are entitled to receive information from your healthcare provider about your illness and the benefits and risks of the treatment options. After understanding your diagnosis, treatment options, and the benefits and risks of the recommended treatment, you have the right to accept or refuse the treatment. This is called informed consent. For invasive treatments, such as surgery, the healthcare provider must have you sign a form indicating that you have been informed about the treatment and you consent to it. This is called a signed informed consent. If you refuse the recommended treatment, your healthcare provider may ask you to sign that you have refused treatment. In the question situation, Mark is a terminally ill patient. Many terminally ill patients become unable to make decisions or let their healthcare providers know their wishes as the illness gets worse. If Mark cannot make decisions or communicate and does not have an advance directive, his healthcare providers have no way of knowing whether or not he wants to stay on the respirator. The best time to write a living will, stating which treatments the patient wants or doesn't want, is while the patient can still make decisions and communicate them. Because it takes effect while you are still living, it is called a living will. It is different from the will you write to dispose of property, which takes effect only at death. Examples of medical situations where a person can no longer make decisions include being in a permanent coma, also called a permanent vegetative state, losing the ability to think competently, such as after a massive stroke, losing the ability to think and communicate due to severe dementia. Current technology could allow Jane to stay alive in a vegetative state for years. However, would Jane want to live in a vegetative state? If Jane has a living will that states whether she wants to be fed artificially in case she becomes comatose, the healthcare providers will honor that. A living will usually addresses a person's desires regarding healthcare if he or she becomes terminally ill and is unable to communicate his or her wishes or is in a permanent vegetative state. A person with a durable power of attorney for healthcare can make healthcare decisions when the patient is unable to communicate his or her wishes. Advance directives for healthcare can be oral or verbal. However, written instructions are clearer and more enforceable. Oral or verbal instructions given to a healthcare provider by a family member or a friend of the patient could be challenged by other friends or family members. Written instructions are much harder to dispute. In medical settings, the term advance directives refers mostly to written legal documents, such as a living will and the durable power of attorney for healthcare. Living will. A living will comes into effect while you are still alive but unable to make decisions. It specifies the medical care you want or do not want to receive if you become unable to make decisions for yourself. A simple living will can include a statement such as, if I should have an incurable or irreversible condition that will cause my death within a relatively short time, or a state of permanent unconsciousness from which to a reasonable degree of certainty there can be no recovery, it is my desire that my life not be prolonged by the administration of life-sustaining procedures. If I am unable to participate in my healthcare decisions, I direct my attending physician to withhold or withdraw life-sustaining procedures that merely prolong the dying process and are not necessary for my freedom or comfort from pain. In many hospitals, a do-not-resuscitate order is documented in a POLST, or Physician's Order for Life-Sustaining Treatment. In a POLST, a patient can request not to be resuscitated. A living will can also include an order not to resuscitate. In addition to protecting the patient's right to communicate his or her decisions in advance, a living will removes the burden of making difficult decisions from family and friends. A living will can include a person's wishes regarding resuscitation, life-sustaining procedures, palliative care, and aggressive treatments, but it cannot cover all medical scenarios. This is why appointing someone to make medical decisions for you when you cannot make them for yourself is important. Some treatments that are not available now may someday become available. The laws in your state may also change. Because of this, you should include all of your wishes in your advance directives, even if the treatments or wishes are not available or legal currently. Healthcare providers who refuse to honor your advance directives are required in many states to make efforts to transfer you to another healthcare provider who would comply. Your healthcare provider may not have an obligation to inform you ahead of time whether they would honor your wishes, so ask them. Hospitals and healthcare institutions, on the other hand, are supposed to inform you at the time of admission. Most hospitals and healthcare facilities, such as nursing homes and home healthcare agencies, are required to observe the following patients' rights. Give you a written summary of your healthcare decision-making rights at the time of admission. Ask you if you have advance directives and document that fact in your medical record. However, it is up to you to give them a copy of your advance directives. Never require that you have or not have advance directives or discriminate against you based on whether you have them or not. Make the facility's policies available regarding recognizing advance directives. Since some healthcare facilities and providers may not honor certain wishes in advance directives, it is very important for patients and healthcare staff to maintain good communication. You should discuss your wishes with your healthcare providers, understand your treatment options, and find out whether or not they can honor them. Sponsored by the Patient Education Institute. www.patient-education.com. Over 5,000 videos and interactive tutorials. DPA for healthcare. A durable power of attorney for healthcare lets you name another person to make medical decisions for you if you become unable to make and express your own decisions. The agent you name acts as your appointed proxy, but only for making decisions regarding the healthcare matters you specify when you cannot make the decisions yourself. The legal document for durable power of attorney for healthcare may include a statement such as, I designate John Smith as my agent and give my agent the power to make healthcare decisions for me. This power exists only when I am unable, in the judgment of my attending physician, to make healthcare decisions for myself. For your healthcare agent to act according to your wishes when you cannot make your own decisions, you must trust him or her. Make sure your agent knows what you want and believe regarding healthcare decisions. The only way to ensure this is to discuss your wishes and beliefs regarding medical treatments with your agent. A durable power of attorney for finances is different from a durable power of attorney for healthcare. Even if you have a legal document assigning an agent to handle your finances in case you become incapacitated, you will need a separate document to assign an agent to make healthcare decisions on your behalf. Your healthcare agent is not liable for your bills and has no control over your finances. In a durable power of attorney for healthcare, you can specify how much authority you want your agent to have. You can also name other people to act as alternate agents if your primary agent is not available. If family members disagree with each other or disagree with the healthcare providers, they may need to go to court to get authority to direct medical care. This is why it is important to appoint a healthcare agent when writing advance directives. Otherwise, healthcare providers and relatives may make critical decisions for you that might not be based on your wishes. You can specify in your durable power of attorney for healthcare the names of people you want to act as your agent. If you do not trust anyone, do not name a healthcare agent. The laws in your state specify who can and cannot be your healthcare agent. Make sure the person you choose meets the criteria. Most states prohibit your healthcare provider and other healthcare professionals from being your agent unless they are your relatives. As you choose your healthcare agent, look for a person who has your trust, understands your healthcare values, and is willing to speak on your behalf, lives close by or could travel to be available at your side when needed. Speak to the person you wish to appoint before signing your advance directives. Confirm his or her willingness to act for you and understand your wishes. Other directives. The living will and the durable power of attorney for healthcare are two forms of advance directives, but there are other advance directives. Your desires regarding organ donation after death are also advance directives. Many states use ID cards, and healthcare facilities use forms to ask if you would like to donate your body organs after death. Answering yes or no to such questions is a form of advance directive. In many healthcare facilities, a do-not-resuscitate-order, or DNR, is documented in a POLST, or physician's order for life-sustaining treatment. A POLST addresses resuscitation wishes. It is another kind of advance directive. A DNR is a request not to receive CPR if your heart or breathing stops. Unless given other instructions, healthcare facility staff will try to help anyone whose heart has stopped or who has stopped breathing. You can also include in your advance directives your wishes regarding nursing homes, blood transfusions, autopsies, donating your body for medical research, and any other issue of importance to you. The living will, durable power of attorney for healthcare, DNR-Order, and organ donation are all forms of written advance directive. It is possible to combine forms into one legal document that lists a patient's wishes regarding medical treatment and appoints an agent. Such a legal document is usually called Advance Healthcare Directives. Legal AD forms. The living will, durable power of attorney for healthcare, DNR-Order, and organ donation are all forms of written advance directive. Some states allow you to combine forms into one legal document that lists a patient's wishes regarding medical treatment and appoints an agent. Such a legal document is usually called Advanced Healthcare Directives. Other states may only allow some forms to be combined, or none. The laws vary from state to state. You do not need a lawyer to write advance directives. Most states require 2 witnesses or notarization for an advance directive to be accepted as a legal document. However, use a lawyer if you think your family situation is complex or if you expect problems to arise. Since living wills apply mostly to end-of-life situations, they cannot be used in cases of temporary coma. For this reason, it is best to write both a living will and a power of attorney for healthcare. You can also combine the forms in one legal document called the Advance Healthcare Directives. Many states have this comprehensive form. Some states have forms for a living will and a durable power of attorney for healthcare. Some recognize one form only. Other states combine the 2 forms. If your state form does not allow you to express all your wishes, you can attach an additional page to the form recognized by your state. To obtain advance directive forms that are specific to your state, ask for the forms at your hospital or healthcare facility. You can also check with your state's medical or legal association. If you use a computer, your state forms may be available online. You can also buy computer software packages that provide the legal forms for your state. The laws in your state specify who can and cannot be your healthcare agent. Make sure your healthcare agent meets the criteria. Most states prohibit your healthcare provider and other healthcare professionals from being your agent unless they are related to you. Plan before you fill out your advance directives forms. The following tips are also discussed in the Planning for AD section. 1. Consider your values and specify your goals. 2. Understand your treatment options and outcomes. 3. Specify your wishes. Specify how much authority you want your healthcare agent to have. It can be unlimited or can follow your wishes in the living will. If your state does not have a living will form, attach a statement to the durable power of attorney document stating the limitations or power of your agent. State laws may put restrictions on what an agent can order. For example, an agent cannot order an abortion. When you are satisfied with your directives, the document should be notarized or signed according to your state's requirements. States usually require 2 witnesses. Some require or permit a notarized signature. It is very important that you follow your state's requirements. Your state form will explain these requirements. After signing your advance directive, give copies to your durable power of attorney for healthcare, your family, your healthcare provider. You may want to keep a small card in your wallet or purse indicating that you have advance directives. You can review your advance directives at any time. Inform your healthcare providers, attorney, healthcare agent, and family of any changes. Changes must be made, signed, and notarized according to the laws in your state. It may be easy to write a new medical directive instead of changing the current one since the signing requirements are the same. In most states, advance directives are in effect until you cancel them or change them. In some states, they expire and you have to renew them every few years. Check your state forms for instructions. You can cancel your advance directives verbally or in writing, but it is best to do it by writing a new directive. Remember to sign it according to your state rules and give a copy to your agent, healthcare providers, or anyone else who has a copy of the previous directive. Destroy your old copy and ask them to destroy their old copies. Preparing for AD. Merely filling out an advance directive form will not help you if it does not reflect your wishes. To have the advance directive reflect what you want, you need to identify your values and goals and understand your treatment options and outcomes. The type of medical care you want in a terminal illness depends on your beliefs and values. Beliefs and values are based on religious, social, financial, or other considerations. They also depend on your self-image regarding the need for independence, dignity, and ability to communicate with others. You should consider your whole value system before deciding on a goal statement that will guide others if you cannot express yourself. Your goal statement could be more than one statement, such as, I want to receive all medical treatment possible no matter what my condition is, or I would like treatment to stop if I am in a state of permanent unconsciousness, or I do not want to prolong my life if I am in severe continuous pain that cannot be controlled, or I do not want to prolong my life if I cannot think, talk, and respond to commands. You need to understand the diagnosis, the treatment options, and their outcomes to be able to state your wishes. Ask your healthcare providers for information. Do you understand the difference between terminally ill and irreversible coma? Do you know what resuscitation, respirator, tube feeding, and kidney dialysis mean? If you are healthy now, it is difficult to know what disease or sudden injury you may have in the future, and what the alternative treatments or likely outcomes might be. That is one of the reasons why appointing a healthcare agent is important. Write instructions carefully so they do not restrict the authority of your agent in ways you did not intend. For instance, do not say, I do not want a respirator, if you really mean, I do not want a respirator if I am permanently unconscious. Some statements can limit your healthcare agent. Specify if they are guidelines to be followed or strict wishes. The more you trust your healthcare agent, the more you should set guidelines rather than strict wishes. If you have a terminal illness, talk to your healthcare provider about treatment options and how they may affect your quality of life. Ask about how they may affect your independence, pain level, and mobility. Check about your pain medications and comfort care options. Finally, decide what health care you would want in a life-threatening situation. Relate your treatment options to your values and check which options fit your stated goal best. You can be as specific as you want. For example, you can say, I do not want a respirator when terminally ill, but I want nutrition, hydration, pain management, and kidney dialysis. Summary. This section includes a 10-point summary of the steps you need to consider when you prepare advance directives. These steps do not have to happen in the listed order. 1. You are not required to have advance directives. Whether you have or do not have advance directives should not affect the quality of healthcare you receive. 2. Having advance directives ensures that your wishes regarding the healthcare you would like to receive in the future are honored when you are unable to make decisions. It is recommended that you write a living will and name a durable power of attorney for healthcare if you trust someone with that responsibility. 3. Advance directives forms are available from hospitals, nursing homes, and home health agencies. You can ask your healthcare provider or check with your state's medical or legal associations. Forms are also available through the World Wide Web and through computer software. 4. Pick a healthcare agent that you trust, knows what you want in life-threatening situations, understands you, and is available and able to speak on your behalf. Name an alternate person if the first agent is not available. Talk to the agents and make sure they are able to fulfill this responsibility and understand your desires. 5. Review your values and state your goal regarding life-threatening and end-of-life situations. Take all factors such as religious, financial, social, and personal into considerations as you state your goal. Understand the end-of-life treatment options and learn their benefits and risks. Choose for your advance directives the treatment options that fit your stated goal. 6. Decide if you want to limit the authority of your agent in your advance directives. Be careful not to write directives that may limit your agent in a way you did not intend. 7. Sign your advance directive according to your state requirements. Give copies to your family, healthcare agent, and healthcare provider. Discuss it with them to make sure they understand your wishes. 8. When you are admitted to a hospital or healthcare institution, give them a copy of your advance directives. Check with them if they have any objections to your desires. If they do, ask them to recommend another healthcare provider that can honor your desires. 9. Review your advance directives on a regular basis, particularly when your values change, your medical condition changes after a serious illness, or you learn about changes in treatment options and their outcomes. Sign the new advance directives according to your state regulations listed on the form and give copies of the new directives to the people that have the old ones. 10. You can always express your advance directives verbally if you do not have time to write them. If so, tell it to as many people as you can so that it would be very difficult to question your decision later. Writing your advance directives makes them more enforceable and legal.
If you like this video, please like and share. For similar videos, subscribe to our channel.
Conclusion. A terminal illness or a sudden injury can leave you unable to convey your decisions regarding your medical care. Advance directives tell your healthcare provider what kind of medical care you would like to receive if you become unable to make medical decisions. The two main types of advance directives are the living will and the durable power of attorney for healthcare. In a living will, you state your wishes about life-sustaining medical treatments if you are terminally ill. In a durable power of attorney for healthcare, you appoint someone else to make medical treatment decisions for you if you cannot make them for yourself. Laws about advance directives vary from state to state. You should use the forms for your state. Forms should be available in hospitals, healthcare facilities, and your state medical and legal associations. Consult an attorney if you think your family or medical situation is complex. Advance directives are not only for the elderly. Incapacitating accidents can hit anyone at any age. The time to write your advance directive is when you can still communicate your desires. This way, you will ensure that your healthcare providers will follow your wishes, and you may relieve your family members of the burden of making difficult healthcare decisions for you. Thank you for using Explain.